Welcome back to Face the Jury, a podcast dedicated to confronting the issues of medical malpractice in America, identifying medical malpractice, understanding it, and discussing ways for you to protect yourself and your family from becoming a victim of medical malpractice. Today we will continue our conversation with Dillon Diamond, who sat as a juror on a 3-week medical malpractice trial and shares his point of view as a juror. Was there a part of the process over the days into the weeks where you felt like y'all had turned a corner and were a cohesive group and not a collection of individuals? I mean, did you feel that there was a moment where y'all were all feeling more connected to each other, or did y'all stay, or did those kind of group dynamics ever take hold, or did y'all stay pretty much in your individual silos? Did friendships develop? Did relationships of some sort develop?
I can't recall. I think it was either on day 3 or day 4. One of the other jurors brought donuts.
Yeah.
And so, because it had been pretty, again, the generic sort of good mornings and whatnot. But then, not surprisingly, food is what sort of opened that up. To where when he had brought the donuts, we then just began sort of chatting more about our personal sorts of lives and perspectives and sharing views one would not share the first 5 minutes when meeting a stranger. Mm-hmm. So after about day 3, day 4-ish, especially after those donuts.
The magic of the donut.
Yes.
The Homer Simpson effect.
Yes, they were wonderful.
Yeah.
And you start sharing sorts of things where by the end of it, there were several individuals in there. Of the 12, 5 of them, I would be more than happy to chat with again and would want to chat with again, have like a drink with them, because they were interesting people.
Yeah.
I wasn't too surprised, but I was surprised at how many people where I was like, oh, I could see you joining my friend group and us going and hanging out over here or doing this activity all together. I was surprised by that.
Was there an initial feeling on the jury? Did you get any feelings of resentment for having to be there or having to be part of it? I mean, was there a sense, was anybody griping under their breath? I mean, I was in the Army and there was, I can't remember the name. We had a name for folks who were just kind of the grumblers, the ones who complained about everything. Maybe great soldiers, but they would be just sort of complainers or bring a negativity to things.
Yes, there was one individual who was like that, which I was kind of surprised because this individual had made it clear during the voir dire process that they did not want to be picked, that they did not want to be on the actual jury. And it did show, in which it was very much where other individuals would be talking or sort of explaining like a funny situation that happened to them, talking about X, Y, or Z. They would not. They sort of kept to themselves and did not make much, if any, probably zero, effort to sort of chat and get to know any other individual. But it was one individual.
Yeah, this is a hard thing to do in jury selection because there's some people who are not going to, don't work for the county or the state. They're not going to get paid if they're on jury duty, and it's really hard to ask somebody to serve and get themselves in the mindset of doing something as important as jury duty when they know that they're hurting financially every day and it gets worse. If I'm correct, I believe the person had financial concerns.
Yes. And I didn't blame this person at all. I didn't have any sort of like, oh, well, why do you feel? They had made it clear. And yeah. I completely understood. And there was no sort of like, everyone kind of understood why this person was the way they were, understandably so.
I found this very interesting because it's hard to talk about these things after the jury is just finished. You're tired. It's the end of the day. So it's been very helpful. And I really do appreciate your candor. You're listening to witnesses. What stands out broadly? You mentioned Dr. Rybicki. Are there any moments that you can think of that stand out that you felt were very important for the case? Or, I mean, you mentioned one, but anything that particularly landed, anything that you found particularly annoying or turned you off? Y'all are masters at looking like poker players on the jury. I mean, somewhere along the way in the How to Be a Jury handbook, people learned, don't show any expression if you can help it. Just stony faced, and that of course drives all the lawyers crazy because we want you nodding with us and smiling, and I'm just joking, but anything come to mind during? I mean, you heard a lot of witnesses, you heard a lot of experts, family members. What sticks in your mind as you kind of survey some of the evidence?
I think as far as like witness goes, I didn't much care for the pointing out of how much money they were making to be there.
Yeah, tell me more about that. Your feelings on that?
I mean, these are professionals who've been to school for like what 12 plus years, 14 years, and obviously it's very expensive to get to where they are. And so they're being away from their practice or their job. So they need to be financially compensated, of course, which I don't even know if it does equal how much money they would have made that day. I just thought it kind of silly that one would spend 12 to 14 years to become a neurosurgeon just to become an expert witness and make money being an expert witness. I find that kind of ridiculous. It just felt like a sort of waste of time where it just seemed like we had to do that every single time. How much does this person get paid an hour? How much are you being paid to be here? How much? I don't care.
Yeah.
Anything, and the amount of time they're being here is probably not high enough to equal how much money that they're losing.
Did you get the sense from jury selection and talking with the other jurors that they had a similar reaction, or was there anybody that was kind of like, "Good Lord, these people make a lot of money," to testify in these cases?
Yes, that was a reaction from, I can't recall if it was one or more individuals, but yes, I forget during deliberation, but it was something akin to the words of like money chasing.
Mm-hmm.
I had like mentally threw my hands up, not literally, but mentally was like, what are you talking about?
Right.
At least the other way, saying that they're professionals and so therefore they should be paid their professional rate, 14 years of school. That was there as well. But of course, one I don't think emphasizes that as much one would emphasize how much money they're making. Oh man, $10,000? Like, of course, for me, that's a lot of money.
Well, of course. Both sides did it, of course. I mean,
Yes.
The defense lawyers point out how much the plaintiff's experts go up first, just the way the case, plaintiff puts on their case first. So the defense lawyers, almost always, well, how much are you getting paid and how much have you made? And, and then, of course, the plaintiffs, I do the same thing, with the defense experts to make the point that everybody gets paid. I mean, everybody and it seems like it is a lot of money that these experts charge, but of course you can't put your case up without them. Do you feel like it prejudiced one side more than the other to point out the money, or do you feel like a pox on both your houses and who cares?
It felt like a wash. Yeah.
Yeah.
It just felt like it almost akin to, I understand there's probably a process to like say, I'm submitting so-and-so to be an expert witness where you ask the same questions over and over. What's your schooling? Where did you do your residency? Like it became a bit rote.
Yeah.
And so it sort of fell into that where, okay, I get it. We'll go for it. But that was just for me. I'm sure for other individuals and for at least one, maybe more individuals on the jury, that did sort of put something in their mind or in their thought process of this person has a primarily financial benefit.
Yeah.
Or motivation, excuse me, as to why they're there.
So you were a note taker, if I recall.
Yes. I had 23 pages of notes.
23 pages of notes. How did you approach your notes? What was give us a peek behind the curtain. How did you approach the note taking? I mean, did you start a new page per witness? Did you put a witness's name at the top of the page? Did you put a line down the middle of the page and for the plaintiff's points, defense points, and or did you just take it down like a stenographer as information came?
Everyone, I think, kind of did their own thing as we were doing the deliberation. People were showing their notes to each other as to how they did it. But for me, I would do plaintiff calls so-and-so, and then notes on that. And then it would be, and I did number 1, 2, and 3 to represent the three parties on the defense. And it would be for the plaintiff, and then a hyphen, what I think was important, hyphen, information I think is important, hyphen, information I think is important. I generally start off with 1 to 2 lines of context, and then things that were actually relevant or pertinent to the disagreements in the case, because there were lots of points of agreement, and so I wasn't writing down every point where there was an agreement. It was, of course, they emphasize, oh, well, this person says this, and then flip over. when X witness gets called, that person said that. So that's how I had it divided up, where there would be cross, defense number one cross, or then defense number one calls such and such witness, notes, plaintiff cross, or defense cross, recross, all that sort of stuff. I had it in sort of the manner of who calls up the witness, what do they say? If any other party asks them questions, they get their own little semi-subtitle, and then they get their sort of thing there. And it was divided up by days. So I had day one, big sort of thing. Everything's day one, day two, day three.
When there were objections and sidebars with the judge, where the lawyers are up at the bench arguing about some point, how did that land with the jury? What impact did that have with you, and what's your sense of how it impacted the jury?
Firstly, I was very surprised at how little the judge actually. It was legitimately like the referee in like a boxing match, where she does not do anything unless one of the quote unquote fighters, one of the lawyers, says objection, or has like a decision, or has like something that like needs approval. Excuse me.
Mm-hmm.
That actually surprised me a ton, because I thought there would be more talking. I thought there would be more decisions on her part, but there was not. And as far as like objections went, personally, I ignored and just assumed this was a part of the show.
Mm-hmm.
I didn't think positively or negatively. The only points is if there was like continued objections. If it was sustained, then I treated it as normal. But if the judge seemed as though like, okay, you get one more question, then another rabbit hole, or get out of this rabbit hole, or one more sort of thing, I personally had been like, okay, maybe there's not much more left to this line of questioning, and I perhaps did not take as many notes or write down as many things when that sort of thing came up. I was like, okay, the judge thinks that this thing has already been addressed, sorted out. I probably have this down somewhere, or someone else does. I don't need to pay as closely attention here. Versus if there's objection sustained and you keep going, and then I'm like, okay, this is. I think it was very explicitly back when that second to last day, where the defense had objected, but then you had made the argument that no, we hadn't actually done the order of how dangerous these sorts of things are in the differential. And then when the judge said sustained and whatnot, and you got to kept going, I was like, oh, this is an interesting sort of thing.
Well, it's a little concerning to me that it took me 2.5 weeks to get to the part of the evidence that you found impactful to your decision making. Maybe the next time I try this, I'll have to restructure a little bit. So, from the viewpoint of the jury, you're seeing these lawyers in court every day. You're seeing the parties in there every day. Do you start developing positive feelings or negative feelings? Do you start sort of identifying with one or more people over others? Do you start developing in your mind, some sort of relationship based on what you're seeing, or at least making some judgments? What's the sort of evolution of that through the trial?
There was like a level, of course, of empathy that became apparent on all sides,
Mm-hmm.
where I obviously had felt for your client, and then obviously had felt for the doctors as well,
Mm-hmm.
because their defense made sure to be explicit, and rather explicit, about just how professional and just how serious they took their jobs and whatnot. So there was like a general sense of all these people feel very strongly that they are perhaps not in the right, maybe that's not the right wording, but let them feel strongly enough and serious enough about their occupations and whatnot. There's like a sort of feeling there. As far as like any sort of thing outside of what your client went through was, and still goes through, incredibly difficult, incredibly tough. I could never understand it. And that sort of empathy of, as a professional, you thought you had done everything right, but then did not do this one thing that had disastrous results. There's an empathy there as well. But I pretty explicitly tried not to look at the plaintiff and not to look at the defendants unless they're on the stand.
Mm-hmm.
Because personally, I wouldn't want somebody to judge me based on the way that I look, especially take your client, for example, especially when one might find it more difficult to laugh and to smile and to sort of have these sorts of things when one is in constant pain.
Mm-hmm.
Like, I'm not going to make a judgment, oh, he didn't smile at that joke. Oh, he's X. And I tried to really sort of not think about that. Because whenever he was actually on the stand, smiles, very affable, answered questions and whatnot, and had the sort of life about him that was not apparent when he was sitting next to his team.
Hmm.
And so I was actually really glad I didn't actually try to make any sort of preconceived notions before he actually went up on the stand, because maybe I would have thought he was a bit more austere, a bit more serious than he was. And also all of his friends and whatnot in the photos showing all of the sorts of dinners and all the sorts of events, all those sorts of parties also helped to sort of color that the individual sitting there, his physical appearance does not mean that emotionally or personality wise, he's any lesser or any less deserving of a fair shake,
Hmm.
if
Hmm.
that makes sense.
Yeah, it does. It does. Take us back into jury deliberations. We'll wrap up in this area, but this is sort of saving the best for last.
Okay.
I'll back up a little bit and pick it up with closing arguments. It had to be a long day, 4 hours of lawyers talking, animated,
Yes.
arguing. What sticks in your mind about closing arguments and on plaintiff or defense side? What did you feel was impactful that had a effect on how you would have voted in the case? What did you feel like was annoying, distracting, maybe offensive? Give us some insights into what it's like to sit as a juror listening to these closing arguments.
From my perspective, I was listening because I had an idea as to how I felt, and I was trying to at least glean the starts of the points that I had wanted to make in deliberation. I, of course, didn't want to sound like a parrot repeating what was said,
Hmm.
but I had felt as though, okay, I felt as though I understood the case. I felt as though the arguments that were made on both sides, and I felt y'all's team had made the case that had convinced me, and I just wanted to be sure that the things that I was going to set forward, that I could point to them and see, because of course you're better at arguing than I am. So the framework that you're using to convince individuals who might be on the fence or on the other side, I need to be thoughtful and think, okay, he said this. What could be the possible response on the defense? And then, of course, when the defense is their closing argument and whatnot, to be mindful of, oh, well, why did I disagree with that? Or why did I not think that that was the case?
Hmm.
And sort of served as reinforcement of things you said. I need to make sure that this is the framework that I'm operating with. Things were said on the defense. Why wasn't I feeling that way at this point in time? And to reinterrogate the conclusions that I had come to. And so that's how I viewed your closing argument and the closing arguments of the defense. I didn't view it, for me personally, as a way to convince, but more as a way to shore up and to see the potential points of issues that might arise and did arise during deliberation.
Were there anything about the presentations themselves that you found were useful, not useful, helped you in some way?
I liked and I'm sure the defense would have done it if they could have done it too. I liked the quotations that you had done, specifically the things that they had said during their closing, and pointed them out and tried to do at least what I was doing in my head. You had explicitly put them on the screen and gone through it. I thought that was rather strong. And what every party had done, I thought was competent and good.
Hmm. I mean, I will say these are top notch defense firms and very experienced, top tier in Georgia defense firms, no question about it.
And again, as far as this is just personal preference, as far as one of the lawyers on the defense, just simply too loud for me, too gregarious.
I won't call them out. I know you're talking about that.
And I had shared this in which I grew up Southern Baptist. I've been to Southern Baptist churches up in North Georgia, which I don't know if you've ever been. There's a certain style in which they speak and whatnot, which is completely appropriate in a religious setting, in my opinion. But in a professional setting, I don't want to be spoken to like that,
Hmm.
especially not in a religious setting. That's not how I personally want to be addressed. I want to be seen as somebody who is to be convinced,
Hmm.
someone who is thoughtful and logical, and who has paid attention, not someone who is to sit quietly fanning themselves with the little fans that one gets sometimes
Right.
as the preacher is wrapping up the sermon. That's the feeling that I'd got.
Yeah. So take us back into the deliberations. You've heard the arguments now. I think there was about an hour, maybe an hour and a half of time to deliberate after the evidence was brought back to you before y'all broke that first night
Yeah.
and then decided to come back. Take us back in that moment. You're walking back into the jury room. You've just finished hearing all the arguments. You've got to be exhausted from listening to argument for 4 hours. What happens?
So we had selected a foreman, or a foreman was to be selected, excuse me. And it was just sort of one of those things where someone had nominated one person, said, you should do it. And that person said, oh, no, I can't do it. And then the other individual who was talkative, who brought the donuts, was like, I'll be the foreman.
So he volunteered to be the foreman.
I mean, it was sort of just like a sort of staring at each other, like a sort of standoff, who's going to say something first. After the first individual who was asked, and who actually I think would have been an excellent foreman and did lead a lot of the discussion, even though he was not foreman, he did lead a lot of the discussion. But it was just sort of like, oh, I guess I'll do it, because he was more talkative and he was more personable.
Mm-hmm.
And the first thing we had done was we had just done a sort of took the temperature of the room, saying let's just go ahead and on the whiteboard determine whether there was negligence, not even gross, just was there negligence, was there no negligence. And so the first votes were as follows. For the neurosurgeon, it was 6-6 in favor of negligence, 6 no negligence. For the ER doctor, it was 7-5, 7 negligence, 5 no negligence. And for the radiologist, it was 2-10, 2 negligence, 2 no negligence.
10 no negligence.
Yes, 10 no negligence.
Okay.
And I was one of the 2. And the other person who was the 2, at least for the radiologist, had said less than 3 sentences the entire 2 weeks, incredibly silent. And so actually that's when my heart started beating out of my chest a little bit. And I said, oh, I can't rely on someone else making these arguments for me or pointing out the thought process for me. I'm actually going to have to do this myself. Is immediately what had gone into my mind when I realized I was one of the 2 and the other person was almost assuredly not going to do any sort of argumentation or the backing up of the evidence that as the way that I had seen it.
Did you find negligence at that first sort of taking the temperature moment? Did you find negligence on behalf of each of the defendants?
Yes, I did. I found negligence in all 3. Yes.
Were there some people who found negligence in 1 or 2 defendants, but not? Well, obviously there were some because the 210 on the radiologist.
Yes.
But as between the surgeon and the ER doctor, were there some who found surgeon negligent, ER doctor not negligent, or surgeon not negligent, ER doctor negligent? Was there that kind of crossover?
From what I recall, it was about the same. It was nearly the same between both of them. It was just one person had jumped from the one person changed from no negligence to the neurosurgeon to negligence for the ER doctor, but it was essentially the same.
So overall, it's a fairly even split on the first 2, and then looked like heavy defense on the radiologist initially. How did that change over the 2 days or 2.5 days?
So first we spent about an hour and a half getting through the Georgia medical thing.
The definition of emergency medical care in Georgia.
That took too much time, in my opinion.
How did you fall down on that initially?
Well, it was just like people had seen the word emergency in the title of as a statute. Statute. People had seen the word emergency in the statute, and like he went to an emergency room, and so they had just thought, oh, well, of course it applies. It happened in an emergency room. And then me and several others had to say, no, wait, let's like read into this as to what this thing is actually for and in what situations this actually applies. Because if these healthcare providers had acted in the way that this statute says that that one would act in, we probably wouldn't be here. This would have been caught, and this would have been sorted out. We wouldn't be in this room.
In other words, what you're saying is that if they had treated this like an emergency and had treated it promptly, Tim would have been treated, and we wouldn't have had the bad outcome.
Yes, according to all the neurosurgeons, like all their saying earlier is better. That was the general agreement. Yes.
So you worked your way through the statute. Where did y'all come down on that issue of whether the statute applied or not?
The statute did not apply. eventually, but there was one individual who had said, well, I still want to put an asterisk in this. And it was like, okay. But essentially, everyone had seen the view that I was presenting of like, this was not treated as, by definition of the statute, therefore the lower level of burden of proof applies.
And just so this is clear to our listeners, if the statute applied, if this was, quote, emergency medical care as defined by the statute, then the doctors get a much higher degree of protection under the law. The plaintiff, in other words, the plaintiff has to prove more. They have a higher burden of proof to hold the doctors responsible if indeed it was emergency medical care. But y'all came down and determined that the statute did not apply.
Correct.
So therefore, the plaintiff only has to prove by a preponderance of the evidence that the doctors are responsible under a preponderance standard, more likely than not. So is everybody in sync on that in the jury? Is that kind of how y'all were approaching it?
Yes, outside of the one person who did the asterisk,
right?
Everyone had come to that view that no, it did not apply.
So now, from my point of view, the plaintiff's point of view, plaintiff is winning. That's a big victory on the plaintiff's side. Now, of course, at trial, we couldn't argue that this was not an emergency. We viewed it as an emergency.
Yes.
It was mishandled. So it became a little bit tricky. And then the defense was trying to say, no, we get the higher standard that the emergency medical care statute provides, but we didn't treat it like an emergency. So
it didn't make any sense.
I'm sure the irony was not lost on the student or the teacher of classic language.
Yes.
An irony. But you get past that. So now
yes.
it's now you've got the lower standard. Take it from there. How did the discussion evolve, and how did people move in their views, if they did?
So we had started with the neurosurgeon, and we had first started off with, okay, if you think there was negligence, let's talk about it. Why do you think this, essentially? Like, what was the process here? I really wish I had this recorded so I could see it again, but I felt as though I didn't lead it, but I had pushed and shared my thoughts for essentially each one as to why I thought there was negligence. Well, other individuals did share theirs, of course, and their perspective. For the neurosurgeon, we talked about what was on the differential, and we talked about him being on call, and we talked about him not ordering any imaging done, not wanting any imaging done that night, and does that show the level of care that a doctor normally provides?
Right.
Does that show that a doctor having only 4 things on a list, 2 of them are already marked out, 1 of them is already being treated for, and you have this one last thing that takes 30 seconds to do and about 45 minutes to an hour to actually go through. And it turned out that record time that the radiologist actually turned that image back around, the study back around, is that does that show the normal degree of care? There's a normal degree of care and skill. And my view was no, it does not. You have 4 things on a list and 2 of them gone, 1 of them already treating for, you have 1 thing left. That doesn't make, and of course with all the evidence and whatnot, people said, it doesn't make any sense to me. I did not think it was gross negligence, and none of us had thought it was gross negligence, but it was significant. And there was that metaphor that was given after we broke down, like you go through the same intersection, the light's always green. The light's always green. And sometimes you looked up at the light just to make sure it's green, but you always drove through it. And then you've been through the light so many times, there's no need to look up anymore. You knew the light was green every single time you've driven through it. And then this one time, the light's red. And it doesn't matter that it was green 99 times before. You were always supposed to look up at the light. That's something that you were always supposed to do. Especially with like a list this small as was presented, and you already had a medical expert take away one of the 2 life-threatening things on that list. You had taken away the 4th one, the hardware failure.
Oh, the hardware
failure. And so, like, abscess is gone, hardware failure is gone. You're already treating for muscle spasm. You got 1 thing left.
Right.
So that's where I determined I thought there was negligence there.
Did that sway people? Let's stay with the
yes,
surgeon.
It did. And when I pointed out in that way, and also the things of you have a change in the condition of your patient where 6 out of 10 to 10 out of 10 pain, the ER doctor told you there's 8 centimeters of swelling along the surgical area. You're given this information. And again, which I thought was very important, the neurosurgeon testified that he knew the pain tolerance of his patient. He knew that his patient was not a complainer.
Right.
So It's not as though he did not understand that this was not a significant change in the condition from when he had seen him earlier that day to his presentation in the emergency room. He knew the pain tolerance. He was his patient for 2 years. And with that argument as well, I felt as though, and I felt it did happen, people had sort of seen that sort of view. Well, you know a guy for 2+ years, you know he's not a complainer, you know his pain tolerance, and now you know he's presenting in the emergency room, and you only have one thing left on your differential that you have not done anything for. You should probably do it.
So did y'all stick with, at that point, after you had the discussion on the surgeon, do you then go to the other doctors, or do you try and get consensus on whether he was negligent?
We did a revote, and then we moved on to the next medical professional.
A revote just as to Dr. Steuer?
Justice Steuer, yes. So
how did the vote change?
I can't recall exactly. I know the final vote was 9 in favor of negligence, 3 no negligence. And of course, that includes one of the jurors who was the alternate. So that had sort of switched out that last day. So there was a little bit of confusion there. But it was 9-3 is what it ended up being.
And I think you had shared with me previously that you felt like the two would have gone with the majority, but there was one who was never going to turn the key.
Yes, I had felt as though, and I imagine if I asked other individuals, they might have sensed the frustration there as well, where no matter how articulate, no matter how thoughtful, no matter how much ground I was willing to give, or others were willing to give as well in this sort of thing, immovable in that regard. And the other two individuals had that wall of not having to actually make a decision one way or the other and be able to defend that decision one way or the other when this one individual was so vocal and so dug in that regard.
Did she give what you viewed as a reasonable explanation for her view as to finding that Dr. Steuer was not negligent? I mean, did she have?
No. She had basically shrugged off every single one of the expert witnesses on the plaintiff's side. Mm-hmm. And of course, and there was the comment of like money chasing or something to that effect and whatnot, making an argument of that's ridiculous and that sort of thing. And where, of course, if a person views that, you shouldn't just throw out the whole expert witness. You should, again, maybe view it in a harsher light. But not particularly, no. I mean, I had spelled out the sort of logic that I had followed, and there was just the repetition of they have not proven with a preponderance of evidence, and then sort of breaking it down, saying like, well, it's just like 51%, quote unquote, or something like that. Are you sure you're not using a higher bar right now of proof? Because me personally, if I was asked clear and convincing, I would say no for all three. No negligence for all three, clear and convincing. But preponderance, yes. And so I don't know if she had also just had thought that the bar was higher, but was then still claiming that it was preponderance. But no, did not really offer much in the way, which I was kind of looking for. I kind of wanted to hear something else in that regard.
Did you have a sense that what was behind that? I mean, did you get a sense, did you feel that there was something unsaid that she was experiencing or that was motivating her viewpoint?
Not unsaid, I feel.
It was said.
Reading between the lines to some degree, but also rather straightforward, is that the individual thought that doctors just had a hard job and had kept saying the phrase judgment calls over and over and over, like it's all judgment calls over and over and over, and had essentially the viewpoint of, because one is doing a career that is difficult, to be clear, being a medical professional is difficult. It's hard to get to that spot. Simply because of a person being in that spot and the fact that they make a lot of decisions seem to be that unless there is a serious dereliction of duty, one could imagine that if the plaintiff had gone to the ER and then they just left him out on the street, yeah, okay, sure, right, she would find negligence there. But the idea that a medical professional, a doctor, could make an error after doing, in my opinion, what everyone would probably expect to be the bare minimum, going into the ER and doing this stuff, the sort of the sheer fact that one is let into the ER, one is admitted into a hospital, seemed to be good enough on this person's end of they're doing their best, and so therefore no negligence could be done.
Interesting. Y'all moved on to the ER doctor, Dr. Hughes.
Yes.
How did that go down?
And that one had followed. I actually felt kind of bad for him because he essentially was between a rock and a hard place of he got the news. He was told by the neurosurgeon not to do any imaging. He does imaging instead. And then he's not told anything out of the ordinary by the radiologist. Is not told, hey, this thing could be compressing the spinal cord. Hey, this is the largest fluid mass I've ever seen in my life.
Are you tired of hearing us repeat that?
I was not tired of it. I was like, this is important. He sees it. Like, you kidding me? It's 30 plus years.
Biggest thing in his career. He's never seen a bigger hematoma in his life.
And so, and especially when one sees the 5 sorts of things that one has to do non-routine communication with, I'm like, I know it's not on that list, but this feels like the same level of things. And so when the ER doctor said on the stand that he felt something to the effect of that he felt comforted or he felt assured because he didn't get a call from the radiologist, I'm like, the only issue and the only concern that I had for this guy is that he didn't share the new study with the neurosurgeon.
Right.
In fact, I mean, he just had to do that one thing, but he didn't. And that was a huge thing that he didn't do, that he decided not to share and not to call up the neurosurgeon of your client and do that. And so that's where the logic was there, is that he'd done a good job.
Was this part of the discussion? I mean, were you this animated during the discussion? I mean, were people saying things like, it was the biggest thing he's ever in his life? I mean, the largest. I mean, was that coming out during the jury deliberations?
Yes. Other people were saying things to that effect, and I as well. I tried to not be as animated, and I tried to sort of say, this is how I view it. I'm open to being changed, but let's have this conversation.
Yeah.
So that way people don't feel like I'm making a personal attack against them.
Right.
It's all just, we're all working together here. So I was a bit animated on the last day. I'll say that. On the last day, I was not tired of it, but I was frustrated that I was not getting any sort of articulation the way that I was articulating how I had felt. And that's where a bit of frustration had come up.
So y'all are discussing, you've moved on from Dr. Steuer, you're discussing Dr. Hughes. Well, what was the vote, I guess, after that discussion?
It was also 9-3 at the end.
A 9-3 on Dr. Hughes, the ER doctor?
And it was the same individuals as well.
Breakout?
For Steuer as well, yes.
Yeah. And then the radiologist, this one's interesting because it started off 2-10 and 10 people thinking he should get a defense verdict.
Correct.
How did that conversation go?
That was the conversation that was like the heart being out of my chest.
And why was that? Did you feel like you were just out there by yourself?
Yes. Well, there's a sort of, I'm on the younger side, right? I'm filled with people that are older than me, nearly all of them older than me, incredibly accomplished in their careers, smart individuals. And so there was some fear was, am I gonna look like a fool as I share this? Am I gonna sound like I don't know what I'm talking about? Am I gonna mess up that impression for when because I said negligence on all 3. Am I going to then, is their view of me going to be tainted then because I articulated this so poorly? So that was a sort of stress behind that. But I felt strongly about it, but I was just worried about how I was going to say it. And the argumentation was essentially that of you are to do a non-routine communication, not because the person doesn't see it quickly. Everything is stat in the ER. The concern was not that he saw it quickly. The concern is how pressing is the thing that he is seeing.
Right.
How dangerous is the thing he sees. I don't care if the ER doctor had seen it in 0.5 seconds. If he does not understand the severity of what he's looking at, because he said on the stand that he had felt, again, something to the effect of he was comforted, that he did not get a call, then that's an issue. There's a concern there. I understand that list of 5 things was not comprehensive. It's not meant to be comprehensive, I'm sure, many of those documents. If things were comprehensive, you'd have things that are 900 pages and whatnot.
And what you're talking about for our audience is that there was a policy that said the radiologist is supposed to call a critical finding, if there's a critical value on an imaging study, the radiologist is supposed to call the doctor who ordered the test and say, hey, I just looked at this imaging study. It shows the biggest collection of fluid I've ever seen in my life. And this could be really serious. I just want to let you know. But there's a list about, I think, only maybe 5 or 6 items on the policy that says you have to call on these 5 or 6 items, and hematoma was not one of them. I think that's what you're talking about, right?
Yes. And
Yeah.
so that was, I thought, convincing to people, where the largest of anything in a 30 plus career is obviously of some importance and of some interest.
Yeah.
And he actually sees the thing. Because of course there were no photos shown of like him like in the ER, back turned over with that's what we have.
Sure.
And so the ER doctor may have been influenced by the radiologist not calling. And
Right.
so it was kind of in tandem where why should the ER doctor get all of his blame when he has this assurance, quote unquote, or like these 2 other of his colleagues not making this feel like an emergency. Again, I do feel as though still new finding, you call the surgeon and tell him the new finding, or the new study, the study. But that's where I felt strongly about that. Is the biggest of anything that one sees is an issue. It's on the spinal cord. It's an issue. And having on your thing, if you have any concerns, call me. Here's my number. But then also the ER doctor himself saying, I didn't get a call, so I wasn't worried. That doesn't do enough for me. It did not do enough to say that, oh, this person was not negligent. And that also ended up being 9-3 as well, or 8-4. I can't actually recall. It was 9-3 or 8-4.
Mm-hmm. And this went back and forth over 2 days.
Yes, Tuesday afternoon, Wednesday, Thursday.
We're fists flying at some point. Were expletives being hurled? Were people pulling their hair out at some point?
The third one, yes, the frustration, because essentially, and not to beleaguer the point, but the way in which individuals had felt there was negligence were, in my view, making thoughtful, well-reasoned arguments according to the evidence that was presented. The individuals who felt the other way were not doing so. And so there was the frustration where it felt as though, at least for me and maybe from others might have felt this way, where it felt as though we had done all this legwork. We had been able to find these points, hook our argument on these points, and then make this, I use the word tableau, to make this tableau of all this, and to come to this decision making. And just to be told in response, oh, it's all judgment calls. Doctors have very difficult jobs. I'm not convinced by the preponderance of evidence. Well, why aren't you convinced of the preponderance of evidence? Well, I just don't trust these witnesses. Why don't you trust these witnesses? Oh, well, they're being paid. The other people are being paid. Like it was very circular in that regard. So by Thursday, there was that frustration.
When did you realize there was not going to be a verdict? I mean, was there a point where you just kind of threw your hands up and said, this particular juror is going to be so dug in and just immovable no matter what? There's no evidence. There's no area for compromise. Maybe let one doctor off, or maybe put less percentage on this doctor.
And it was so interesting because I was very flexible in that regard. I was, for the sake of flexibility and for the sake of the system to work, I felt as though as it should. I said, look, if we want to say if we can say no to the radiologist, but there's more agreement with the neurosurgeon and the ER doctor, let's go this way. And let's keep this conversation going, because as long as this keeps feeling productive, I feel as though this process is working. But it was the wheels had kept on spinning around where there was no willingness to move. I was very explicit where I said, I am not clear and convincing evidence. I'm not convinced, but preponderance I am. And I gave all these reasons as to why. So I made vocally clear that I was moving and being flexible, and others as well were being flexible in that regard. But there was no flexibility on the other end or on the other side.
So you have been more than generous with your time. We've gone almost 2 hours, I do want to wrap up because I know you've got a life to live besides this podcast. But just in sort of final thoughts, looking back on this experience, what do you think are the pieces that are going to stay with you? I guess the first question I would ask is, even though y'all were not able to reach a verdict, how would you sort of rate this experience in your life? I mean, what are you glad? Are you glad that you got selected?
Yes,
You are. Tell us why.
it was a great experience. I mean, even with the frustration a little bit there at the end, it was great. From a personal perspective, many individuals might find it difficult to have pride in one's civic institutions nowadays.
Mm-hmm.
Lots of divisiveness and lots of anger. And it felt really good. And I had, like, whenever it was all said and done, it was like, of course, like a weight. The roller coaster ride is over. But I was glad I'd ridden it, where I felt as though I especially whenever I had felt as though that 210 for the radiologist, going from 210 to 8.4 or 9.3, I can't recall. It was like I felt like I did my job as a citizen,
Mm-hmm.
and that was really fulfilling on my end. A bit too long. 2 weeks is a bit too long.
2 weeks is a bit too long. Actually went into the third week because we lost those 2 snow days.
Yes.
And I mentioned this too when we talked after the trial, but we had a big meeting with all the jurors on Zoom and the judge and all the lawyers, and we put all the jurors off into breakout rooms. We pulled you in one by one, and we were all holding our breath because the judge was asking if people were willing to go into the third week because you hadn't been, quote, qualified or committed to a third week. And the judge,
Mm-hmm.
my impression was she was very open to people saying, I just can't do it. I've got whatever. And my impression, I don't know, but that she might have let people off and declared a mistrial. And one after the other, every juror that came on said, I am willing to come back. I am willing to even though there's ice on the ground. One person said, I'll do what I have to do. It was, you could almost hear the Rocky music playing in the background because we were all very relieved that the level of commitment, and where we were afraid the whole case was going to be derailed before even getting back to final deliberations. But so that's great to hear that this was a positive experience for you. Any final thoughts before we wrap up about this experience?
No, I honestly wish more people would feel a bit more excited about doing this. I understand not all the cases are as in-depth or as tricky as this one, but I think this idea that, oh man, I'm going to jury duty, which I felt many similar sorts of feelings, went away after the experience. And all the people that I've told about this experience really were interested in it and really wanted to hear the story. So I wish the state would do more to say, no, jury duty fills a very important purpose in our society. You should, if you are the right person for the jury, you should want to try to be on it, being honest and coming in there with your life experiences.
Mm-hmm. Well, Dillon, I really do appreciate your time today and opening up to us and giving so much thoughtful feedback. This is going to help. I think it's going to help all kinds of lawyers and folks listening to it appreciate our system, but also answer questions that we've always had about how jurors approach these things. What's the thought process? This is just I'm very grateful because I know this is going to make me more effective when I go back to the next trial with Tim to try and ultimately get him his just verdict, but all my other clients as well. So I just can't thank you enough, and it's just been a pleasure having you on Face the Jury.
Yeah, thank you so much. It's been great.